There are actually about 17 different factors that the court looks at to decide parenting time, but by far the most important factor is what I call the status quo, which means what is happening right now. So if you go into court, the court's going to say, who's raising this child right now? So if you have possession of a child, that's usually the best time to go into court if you want to get custody. But that doesn't mean you will get custody. Oftentimes, people go into court, they have the child, and then the court looks more closely at the situation and decides it might be in the best interest to be with the other parent or for the other parent to at least have more time. The court can really look at anything that they want, and their focus is going to be what's in the best interest of the child. It doesn't matter so much what you want or what the other parent wants, it's what's best for this child. How are they going to be raised in the best way in a stable environment that encourages their mental, emotional, and psychological growth. That's what the court is really looking at. There is no doubt that it's in the best interest of the child to get quality time with both parents. And that's what both parents are usually fighting for in a custody case. And the longer it takes to figure out how to give both parents quality time, the longer a custody case goes on, the more money it costs, the more stress it causes for both parents, and the more stressful it is for the child. So as attorneys, what we do is look for creative methods to get both parents quality time. So we look at what's the work schedule of this parent, what's the work schedule of this other parent, and what's the school schedule of the child, where do they go to school, and then we figure out how can we make this work so that both parents have quality time. Maybe it's during holidays, maybe it's over the summer. There's a lot of different ways to put this puzzle together, and that's what our job is, to figure out how we can do it in the best way for the child. When both parents want full custody, meaning they want to be the primary parent for the child and maybe the other parent gets every other weekend, if they can't come to an agreement as to how to split the difference, say, and do a 50-50 schedule, what's going to happen is a guardian ad litem or a child's representative most likely is going to be appointed. That is an attorney that represents the child and does an investigation on the child's behalf and gives a recommendation to the court as to what happens. If the parties still can't agree, then there's another level of expertise and litigation that happens to resolve the difference. If they still can't agree, the case might go to trial, and what happens at trial is the judge is going to decide what's in the best interest of the child. It may not be for this parent to get full custody or this parent to get full custody. The court could say no, 50-50 is what's going to happen. Although the court could also side with you and say, yes, you're providing the most stable environment for the child, and you should be the primary parent. A lot of people wonder, what's the difference between joint and sole custody? Well, let's back up a little, because in Illinois, we actually don't use those terms legally speaking. It's called allocation of parental responsibilities. And there's two components of that. There's significant decision making, and there's parenting time. And what the court decides is how much parenting time are you going to have, and whether or not you have significant decision-making authority. So I think when we say sole custody, what we mean is we have the majority of parenting time and we have all the decision-making authority. So that's really the difference. Sole custody is decision-making authority and all the parenting time, or most of it. And joint custody is where you're splitting the decisions and you're splitting the parenting time pretty much 50-50. In Illinois, child support is calculated using the income of the parties and the amount of overnights that the parties have with the child. So you take the income of both parties, you put it into a calculator, and that gives you a child support number. Now, how much you actually pay is going to depend on how many overnights you have with the child. Right now, as the law stands, if you have at least 146 overnights per year with the child, your child support is going to be drastically lower. So it's actually between 40 and 60% of the time with the child, and your child support is going to be much lower. So there is a financial advantage to actually getting more parenting time with the child. If you don't pay child support, you put yourself at risk to be found in contempt by the court. And what that means is the court will look at your situation and decide whether or not you had a good reason to pay child support. And what you think is a good reason and what the judge thinks is a good reason may not totally align. What happens if you're found in contempt is the judge is going to say you have to pay X amount of dollars within 14 days. So maybe it's $2,000 within 14 days. If you don't do that, you could actually end up in jail. At that point, if you don't comply with the judge can have the sheriff go out and arrest you. Since being licensed in 2012, I've been practicing in the area of child support and custody, and have probably helped over 500 families resolve custody and child support issues. And as the law has changed over the years, I've followed the law to make sure that when a client comes to me with their issue, I know exactly where they stand legally speaking. Clients hire us for three main reasons. First is our reputation. We work incredibly hard to build our reputation of professionalism, integrity, and honesty with other attorneys and with judges, so that when we're representing clients, judges listen to what we say and listen to the arguments we're making, so we're able to get better results for our clients. The second reason is because of our experience. Everybody from myself to our attorneys to our paralegals has been practicing family law their entire career, so we're very familiar with the laws at hand and how the court system works. The third reason is because of our compassion and empathy. We understand that every client brings their own unique story. And that's why we do this, because we want to learn that unique story and help that person with exactly what they need help with. Our current and past clients would point to the personal nature of our representation. From the first time that you call our firm, you'll tell that our receptionist truly cares about who you are and what you're going through, and they're going to connect you with the attorney or the paralegal that can best help you at that point. They're going to want to know what is going on with you right now. What is that pain that you're feeling, or what is that problem you're having, or what are you trying to achieve? From that point, we're going to want to understand even more so we can help you exactly at the point that you need it. We know our clients by their names. They're not case numbers, they're not client files, but they're actually people that go through problems. They share pictures of their families with us, and we learn about them and we get to know them throughout the course of a case. Client communication is incredibly important to us. It's actually the number one complaint that people make when they're not happy with their lawyer, so we know we have to focus on that more than almost anything else. We've made it easy for our clients to get in touch with the attorney or the paralegal on their case, and they can reach out either by text message, by a phone call that will get returned within 24 hours, or via email. If a client is not getting the communication that they deserve, that's something that's going to be addressed immediately and resolved without issue. We're a boutique family law firm, which means that we have a small number of attorneys who are very well experienced in handling anything from routine matters to highly complex divorces that may involve complex property division, business evaluation, clinical psychological experts in custody disputes. Our team is built so that we can work efficiently and effectively. We have an attorney who's managing the entire case. We have a paralegal who's handling all the documents, and we have a legal assistant who's helping the paralegal not to miss anything. So we cross all the T's and dot all the I's. As the attorney captains the ship, if you will, everybody on board is working to make sure that we're going towards the same destination, and that's the client's goals. If you're watching this video and you're thinking that you need some legal help, the best thing that you can do is to call a firm and book a consultation. There's nothing that replaces getting a one-on-one conversation with an attorney who knows the law in the area that you're having a problem with. You can either find an attorney by asking your friends or your family that maybe have gone through a similar problem if they know a good attorney, or you can look online. If you're looking online, make sure the attorney that you contact has good reviews on Google frugal, that doesn't have any negative marks on their bar record, reach out to them, book a consultation so you can get one-on-one help. At your initial consultation for child custody or child support, we're going to learn about your situation. Most people come to a child custody or child support consultation when something has recently happened. I often ask clients, what's the straw that broke the camel's back here? And there's usually something that happened a few days prior. Maybe the parties got into some sort of blowout fight and one said, you know what, you're not seeing the kid anymore. And you knew that you hadn't talked to a lawyer. We're gonna figure out how long those problems have been going on for, what your current situation is, and what kind of relationship you want with the child. Maybe you're protecting your child from an abusive parent. We're going to figure out how serious that is and whether or not we have to go to court on an emergency basis to keep your child safe. No matter the situation you bring to us, we're going to figure out the best legal solution and tell you what it is, and you can decide what you want to do at that point.